Get started. I appreciate everybody joining in. I hope everybody's staying reasonably warm and safe. Today's Get Smart class is on transactions where you have a trust as a client. And so a little bit ago, maybe 5-10 minutes or so ago, I sent out the primer for this class. And that's what you should see on my screen share. And we're just going to, like we have on the other classes, we're just going to work our way down through that. And so, again, I think maybe the first thing to talk about is what is a trust? You'll hear about it a lot in terms of in an estate planning context. And that's generally why real estate ends up being put in the trust, is for estate planning purposes. But unlike corporations or LLCs, for example, a trust really is not a business entity. It's not like an LLC, and it's not like a corporation in that sense. Rather, a trust is really a contract, and we refer to that contract as the trust agreement between at least two parties, but really there are three involved. The creators of the trust, and you'll see different terms for those, can be referred to as the grantors, the one granting the property in the trust. More often than not, you'll see the word trustors used, and you'll also see occasionally the word settlers used. They're all the same. Those are the people creating the trust. The other significant party to the trust is the trustee. And in here, I'm going to use the word trustors to in this primer to refer to the people who create it. And then, of course, the trustees, that sometimes you'll see the word grantees, but almost everyone just uses the word trustees. So a trust is a contract, a written agreement by which the trustors transfer legal title to the people named or person named as the trustees to manage that property in accord with the terms of the written trust agreement. And it's really that simple. Now, it can get obviously pretty complicated. So remember, as we mentioned, the trustors are the people who have the assets. They're transferring them to a trustee, and they're held for the benefit of the beneficiaries of the trust. So trustors, trustee, beneficiaries. In a typical estate planning context, they can all be exactly the same. So I'll just use me personally. I'm married to Brenda. Brenda and I, for estate planning purposes, we want to create a trust to hold our house. We might call that the Brian and Brenda Lytle Revocable Living Trust. Since it'll have a date to it. Let's say we execute it on January 1 of 2021. We would then say it's the Brian and Brenda Revocable Living Trust Agreement dated January 1, 2021. And now Brian and Brenda are the trustees. We're the ones putting our house there. We're the trustors. We're the trustees, and we're also the beneficiaries. So we wear all those hats. We're creating a trust for our benefit to be run by us for the benefit of ourselves as the beneficiaries. Now, just so you know, and one reason there are technical legal terms for it, but a revocable living trust doesn't get an EIN with the IRS. It doesn't pay taxes. It's really the trustees who are acting. The trustees hold legal title to the property, and that's why, as we'll see in a contract, the trustees are the ones signing the listing agreement, the ones signing the contract, the ones getting the loan if that's allowed. So it's the trustees that are acting. They're the ones, like the president of a corporation, although it's different. In this case, it's the trustees, and you can think of them in a similar sort of a way. The reason trusts are used a lot, and you see them, in the real estate context in our profession industry, is they're great estate planning tools, because if Brian dies, for example, in my example, well, things just keep going the way they are. Brenda is now the trustee. The house is still, Brenda still holds title to the house as trustee, and the beneficiaries, Brenda's still a beneficiary. So in that written trust agreement, we're going to specify how all that's going to work, and it's going to happen by agreement or by contract. You don't need to probate a will or do a new deed or anything of that nature. So that's why they're really good estate planning tools. So that's why you might use a trust, is it avoids probate. That's what I've mentioned here. So that's why you see a lot of real estate held that way. As I mentioned, it's the trustees that hold legal title to the property. The trust itself, the agreement, it isn't registered with the State Corporation Commission or anything like that, because it's not an entity in that sense. So trustees are always signing in their capacity as trustees, as the legal owners of the property. If trustees die or become incompetent or have Alzheimer's or something like that, the trust agreement is going to specify who steps up into the role of trustee or co-trustees, whatever you may have. And they're typically called successor trustees. And you guys are going to see those, successor trustee. So, if Brenda and I were to pass away, it might be my son, Thomas Lytle, successor trustee, the Brian and Brenda revocable living trust dated January 1, 2021. That's how that works. The trust agreement itself is going to say that. Can a trust buy and sell real property? Well, it can if the trust agreement says the trustee can buy and sell real property. There's no inherent right or ability to do that. It needs to be listed because, again, and to point out the obvious, it's not the trust buying or selling, it's the trustees. And so we need to look in the trust agreement to see whether the trustees have the power to sell real estate. They might not. It may be that the trustors, the ones who originally created the trust, didn't want the house being sold, or the family property in Albemarle County, they wanted to try and keep that in the family. So the trustees weren't allowed to sell it. It was eventually going to pass to the beneficiaries. So we always need to look at that. If you were able to join us in our classes on corporations and LLCs, we always listed for you the governing documents. Well, the only document here really is the trust agreement itself, because that's the contract that specifies how that property is going to be held and what can be done with it by the trustees. So you guys take listings, buyers buy property and they want it in the trust. So what's required when a trust sells real estate? So First American, just like I went through on the other classes, First American is going to want to see a copy of the trust agreement, because as I just mentioned, we need to see what is allowed to happen with that property, who are the trustees or who might be the successor trustees. All of that needs to be vetted. And since that's really the only governing document, so to speak, that's the only one that needs to be provided. I've listed here what's known as a trust certificate. Virginia law allows for an affidavit, a certificate, to be executed by the trustee that says, this is the trust, I'm the trustee, I have the power to do this, and so on and so forth. And Virginia law allows third parties to rely on such a certificate. So it's not just First American, by the way, they're all going to require it. Everybody wants a copy of the trust agreement to kind of see it for themselves, but technically that doesn't have to be provided. It's just usually easier to do it that way. But you can, in a pinch, rely on a trust certificate. The third party does have the right, in addition to the a trust certificate, to furnish, particular pages of the instrument verifying what the trustee is saying under the trust certificate. So that's what's really required. It's not a whole lot when the property is a trust is selling, or trustees, let me say that correctly. It's the same thing when you got buyers who want to buy and they want the property to go into their trust. So now if it was a cash deal and they're not getting owner's title insurance, then nobody's really going to care. Well, we should care, but nobody's going to require them to prove that that's okay. They're the ones that are solely going to bear the risk if they're wrong. But if they're trying to get a loan that way, or they're going to get owner's title insurance, which they should, it's the same thing. Want to see the trust agreement to make sure that the trust can acquire and hold title. The trustees can hold title to the real estate. The trustees have the power to spend the money to do it, to execute loan documents, so on and so forth. And it can be handled. The same rule about trust certificates applies there. So I know I'm talking pretty quickly because I don't want this to, you guys just, I want to move through it as quickly as I can and let you get back to work. So I do know that I'm moving through it pretty quickly. I've got the chat up. So if you guys have questions, just, put them down on the chat line and I promise I'll address them. Just like with the other classes, I've given you a couple of sample emails. You can just cut and paste. So it would be to your buyer client who wants the property to go into their trust. Give you a heads up that settlement agent, title insurer, I've highlighted, and your lender, because it might be a cash buyer, what's going to be required before closing. I put in the language here, if you have any concerns about providing the entire trust agreement, to let you know, and then you guys reach out to me and we'll figure it out and do the minimal amount necessary and tie that into the certificate to get it done. If they don't care, and most people seem not to care, and there's no reason they've got, unless there's really super duper private stuff in there, it really just isn't an issue. It's just easier to provide the trust agreement. And then a similar email that you can cut and paste to use to send to your listings where there's a trust. Again, just giving them a heads up about what's going to be required and to get that started. Tiffany's asking, what happens if only one spouse is named a trustee, but they die before the other spouse? Well, Tiffany, as we talked about, so if everybody understands Tiffany's question, let's go back to my example. It was let's suppose it's just Brian D. Lytle, trustee, the Brian D. Lytle Revocable Living Trust, or it might even say Brenda there, but the point is only Brian is the trustee. And you got that listing and you find out that, well, Brian's dead. Some of you have suspected that for a while, but let's just assume that to be true. I hate Zoom. I just can't get any laughter from anybody. But in any event, Brian's laughing. Thank you, Brian. In any event, what you do is, as I mentioned, you look to the terms of the trust agreement to see who is named as the successor trustee, right? And then that's going to be the person signing. It would be Brenda Lytle, successor trustee, the Brian D. Lytle Revocable Living Trust dated January 1, 2021. So we look to the contract, to the trust agreement to tell us that. And as you can imagine, banks and lenders and settlement agents and title insurance companies, that's kind of important. We don't want anybody just saying, hey, I'm the successor trustee. I'm going to spend, $500,000. Trust me. Well, it doesn't quite work that way. So we look to the instrument itself and vet that out, just like we do in all sorts of situations on closings. What can go wrong? It's the same thing on the other transactional primers. You just don't start soon enough getting all the documents. If you give the client a heads up early about getting the trust together, if you know that somebody's died, we're going to need to show who's the successor trustee, get work on the certificate. So if you just address it in the beginning, I will tell you that quite often that we have problems. Agents just don't list it right. They don't note that it's a trustee and a trust. And if you think about it from like Lytle Title standpoint, well, we don't know. We're not going to know until the title search is back. And then somebody's got to focus on it and look at the contract and say, well, hey, that's different. It's not right. And then, everybody typically, how things go, you're scrambling around at the last minute to try and get all that straight. So early and often rather than late helps a great deal. And I've noted here, the worst kind of thing that happens is, as Tiffany asked, a trustee has died and we've got to get, somebody qualified. A related problem is, it seems like it's happened a lot. Like, we've got a named trustee who might have Alzheimer's and is no longer competent. And so in those circumstances, the trust agreement itself should say how you determine if somebody's incompetent and, what happens in that case. And a lot of times, and we've had this, I don't know, half a dozen times in the past year, it seems like COVID's made all this worse. Mom may be the surviving trustee. She now has Alzheimer's. And we've got to get a doctor's, the trust agreement says you get a letter from a physician declaring her incompetent. That becomes hard to do because doctors aren't going out to nursing homes and you can't get the nursing home resident with Alzheimer's to a doctor. And so those kinds of things, that's usually the worst that happens. We've worked around all those. It just takes time and the closings get delayed quite a bit. So if you see anything weird about your trust situation, maybe the person that's telling you they're the trustee is different than who's shown as a trustee on the tax records. Those are the times to reach out and get started very early rather than later. Bryant's asked me, okay, I guess to follow up on what I was just talking about. So Bryant's asking, when we look at a tax record, will this state if it is in a trust? It should, Bryant. And I just looked at one. I think Faith's got one going on now. It can sometimes be a little tricky where you see the person's name and then they might just put comma at the end, all of it, and they'll say TR. Well, what that TR is trustee. Some jurisdictions are better than others and they'll put the word trustee. I've never seen any of them list the name of the trust agreement, the name of the trust, in other words. But they will usually have TR, TEE. You'll see that a lot. Sometimes you'll see trustee spelled out. So yes, you should see that in the tax records. You guys may remember in all my, the ones that I've done so far on corporations and LLCs and the like, I've shown you how to look it up on the Virginia SEC. You can't do that with trusts. They're not legal entities. You're not going to see them formed that way. How do they sign? Well, so this would be a block signature like I would do on a contract or something I'm drafting. It's the way you'll see it on a deed, for example. Again, it's not a legal entity. So up here somewhere, we don't put the name of the trust. You'll see that occasionally, but it's not really the right way to do it. This is how you do it. It's Brian D. Lytle, trustee. That beautiful looking B is my way of saying or signing Brian D. Lytle, trustee. And then underneath that, we identify trustee of what? And that's, in this case, the Brian Revocable Living Trust dated December 13th, 2003. Anybody tell me the significance of that date? I'm looking at the chat. Come on, guys. Somebody, Donna knows.
It's when we opened.
There you go. That's when the company was formed.
Mm-hmm.
It's a shame Liz isn't here. I was just giving her throw out to the anniversary.
I'm here. Watch yourself.
All right, there you go. Liz, that's a big anniversary for Liz. I get in trouble if I miss that, and I miss it a lot. I'm sorry. So this is my way, Liz. This I'm good. I'm good now through next year on that. So no, she's shaking her head. All right, to finish up, Caitlin was kind enough to try and give us a transaction desk electronic sample, how you guys would do it. It's still really hard on a trustee. If you look back at the other primers, corporations and LLCs are very easy. Trusts aren't, because they're usually so daggone long. You know, you're trying to put all of that in there and it doesn't work that easily. So for example, on a seller, you're choosing here that it's a seller, the name of the seller, the full legal name of the person, you know, would be Brian, as we've talked about, Brian D. Lytle, trustee, Brian Revocable Trust, dated, and you can see that kind of gets cut off. The signature is easy enough. That's just Brian D. Lytle, trustee. So let's see how that looks. Let me see if I can blow this up a bit. Hold on. Maybe that's too much. Bear with me here, guys. All right, so remember that one field is trying to fit all this in. I think it fits Brian D. Lytle, comma, trustee well enough. And Caitlin, you're welcome to weigh in here. But it didn't have all of this, and you had to go back and re-enter it in a text box. Is that right, Caitlin?
Yes, so it fit up to revocable, and we had to create the next, or put the next text box starting at trust.
Okay, so I'd love for you guys to do it that way, but I think you got to do that everywhere these names appear. And I know that's a lot of work, and I doubt you're going to do it. So another way to handle that would be to have, this is just too big. So you could right here put Brian D. Lytle, comma, trustee, and then do an asterisk, and then link that asterisk in some other part of the contract. I think it's still paragraph 12 of the RAIN contract, wherever you got some blank room, and do the whole thing. And hopefully you'd only do that once. But to be clear, it's legal if you just have Brian D. Lytle, trustee, because I've said, and it is, I'm right, that, you know, I own as the trustee, any trust, it's the trustee that owns legal title. The rest of this, it's nice, it's helpful. Yeah, maybe that's just the easiest and best way to do it. Shoshana's pointing out it picks up the second line as another name, messes up. So, you know, I'll let you guys kind of work on the best way for you guys to do it in transaction desk. And maybe the best way to do it is just the comma trustee and let the rest of it go. And then so you have your preferred signature as Brian D. Lytle, comma, trustee. So that's how that's going to appear, and that's fine. And then your seller, just like I did in my signature box above, is just Brian, comma, trustee, or whatever you may have. So that's, I was trying to signal to you here. Trying to complete that in a text box is a pain. And so I can live with Brian D. Lytle, trustee. You know, if you got some time and you can figure out how to make it work easily, you do the asterisk. If not, I think you still have a valid listing, buyer broker agreement, contract, whatever, if you're just saying Brian D. Lytle, trustee, or the equivalent, because that's in fact true. It's just helpful to add the rest of the stuff, but not legally required. Valerie, should you put in the contract additional provisions that the sellers? Valerie, I think that's a terrific way to do it. You know, the comma trustee should really signal to everybody that a trust is involved, but it's really helpful to identify the particular trust, get everybody working off the same sheet of music. So yes, that's Again, not legally required, but I think it's very, very helpful. Shoshana's asked, what about an amendment to clarify the name? If you've already got a good contract and it's got comma trustee and everybody seems to be okay, then I don't think you need an amendment. I can't tell you, you're not going to have a lender or some settlement agent that wants all of that added just because. And, if they request that, then you add it. If you start off with an individual and then you find out it's really in a trust, yes, you're going to need an amendment to identify the trustee's role correctly. So I don't see any other questions. And once again, I appreciate everybody tuning in. I'm not sure what the topic is next week, but I'll, excuse me, I'll send that out pretty quickly.
Next week is powers of attorney.
Okay, that's a good one. So powers of attorney. I know there's all, we do those a lot, and you guys always, have questions and need us to do those. So that'll be a good class. That one should be, again, within the 15-20 minute time frame. And I'll send out the primer shortly before that. Before I do go, I got a couple. Ruby asked about using a power of attorney to sign a trust. All right, so that's a great question, and it's a complicated answer. So again, suppose that it's the Brian Trust. I'm the trustee, and I'm not around. And so my wife Brenda wants to use a power of attorney I've given her to sign for me as trustee of the trust. Can you do that? Well, maybe. The general rule is no, because the power of attorney would only have given her the ability to sign for me in my personal individual capacity. And so in a minute, I've got to grant her the power to act and sign for me in the fiduciary capacity as trustee of the trust. And then on top of that, the trust has to authorize it. So sometimes we can do that. Most times we can't. We just have to evaluate it on a case-by-case basis. Can people put trustee in a refinance? Tiffany's asking if the property's held by the trustee of a trust and they want to refinance their loan, then theoretically, yes, they can refinance the same way they're presently holding title. Many lenders don't want to do loans, whether they're refinance or purchase money in the name of a trust, because there's risk to them in doing that. The trustee having power and so on and so forth. They just don't want to deal with it. So what we typically do then is we convey it out of the trust, put it in the individual names. Then when the transaction or refinance is done, we put it back in the trust. That's perfectly appropriate and legal. Federal law specifically says that due on sale clauses and the like are not triggered by transferring property to a revocable living trust. So,
Brian,
yeah.
can I point out one more thing?
Yeah, sure.
So this is kind of like you're my work husband compared to my real husband. And my real husband can't remember our anniversary. So would you like to tell everybody when our real anniversary is?
Oh my God, did I get that wrong?
So just in case anybody is doing trivia, our anniversary is on the 19th of December.
I knew that.
And Brian is in a lot of trouble.
I knew that. I was just trying to see if you were paying attention. Oh my God, I'm in trouble.
I'm sorry, Brian, for not catching that.
Oh my God, I'm in so much trouble.
No, he was just prepping to be ahead of the game to make sure he said happy anniversary. So.
Okay, well, I think we'll probably end the class on that note. Peggy's shaming me in the chat room, and I guess I deserve to be shamed. There used to be a clock in the training room here, and I can't remember now, so I'm sorry. Any other questions? You guys have a great day. Stay safe. See you next Thursday at 3:00 on Powers of Attorney.
Thanks, Brian.